going to do just brief introductions of all the panelists so that we can get to the meat of the panel. Their full bios are in the packets that we've given to you. And I'm not going in order. And I am particularly grateful for James Sandman's presence today. He actually lives in D.C. because that's where the Legal Services Corporation is, but he flew in from Los Angeles this morning to be with us. James Sandman has been the president of the Legal Services Corporation since 2001. He practiced with the law firm of Arnold and Porter. He was the general counsel for the District of Columbia school system. He was also the president of the D.C. Bar. He was named one of the 90 greatest Washington lawyers of the last 30 years by the Legal Times. That's something in the District of Columbia. The only bone I have to pick about James Sandman is that he's a graduate of University of Pennsylvania, where I did not go, but a perfectly good law school. He's extremely committed to access to justice and ensuring that low-income individuals receive the best that they can from the Legal Services Corporation and throughout this country. William Hornsby is a counsel in the American Bar Association Division for Legal Services, where he provides staff support for the Standing Committee on the Delivery of Legal Services and the Commission on the Future of Legal Services. But when it says staff support, that is an understatement. Will Hornsby is the Standing Committee on the Delivery of Legal Services. And how do I know that? I was one of the committee members, and he does a wonderful job. It is one of the most active standing committees of the American Bar Association. He is devoted to issues relating to moderate income individuals. He is also a law professor at, it doesn't say which law school, but I know he teaches. And he's a foodie, which is also, I like that. But number one is that he also is an advocate for individuals in this country who require access to justice, but his bent is the moderate income, and I consider him a good friend. And he has come from Chicago to be with us today. Judge Dina Fein serves as the first justice of the Western Division of the Massachusetts Housing Court, which she joined in 1999. In 2009, she was appointed as the Special Advisor for Access to Justice Initiative across Massachusetts' 7 trial court departments. Basically, she's Judge Fern Fisher for Massachusetts. Yes, she is. We met a few years ago when she first was appointed to be the special advisor, and we bonded instantly because we see the world the same way. Massachusetts is doing some great stuff. Unfortunately, she's not here to talk about anything but the limited scope bent of what's going on in Massachusetts, but I urge you to look at Massachusetts' website, and if you're interested in other topics, bring Judge Fein in for that. Attorney Laura Unflat is perfect for today's conversation, and I particularly wanted a family law practitioner to be here. She conducts a domestic relations practice in Boston and surrounding communities from her office in Wellesley, Massachusetts. Her entire practice is concentrated in family law issues, including divorce and post-divorce matters. I'm sure she'll have something to say about that hypo. And she was an early adopter of limited assistance representation. She's an elected member of the Boston Bar Association Council, and from all I hear, because we just met today, she came recommended by Judge Fein, and I do whatever Judge Fein tells me to do. I'm sure she's going to be a great speaker, and she's going to talk to you about the actual nuts and bolts of running a limited scope practice for paying clients. We have plenty of time for this panel, and we hope that you will jot down your questions. I'm going to try to keep them towards the end, but if you have a burning question, raise your hand. It's okay. We're going to start off with Will Hornsby.
Okay. Thank you. To supplement my bio, I just like to start by saying nothing I say this morning should be deemed the policies of the American Bar Association or any of its constituent entities. Are there any questions so far? Okay, great, thank you. In the ABA, unlike many of the state and local bars, we have term limits for participation in many of our committees, including the delivery committee, and it's a 3-year term. And frequently I'm like, yeah, great. But when Fein rotated off, it was a very sad day for us. So I am so glad that we've been able to continue the conversations that we participated in. So I'm going to give you kind of the 30,000 feet view of unbundling around the country. And hopefully hone in on what some of the needs are at this point in this experiment. A little more than 20 years ago, we started to notice that there were more and more pro se litigants, and this was concentrated in family law, was something that emerged in different jurisdictions. It was actually more common in the West than the East, but it spread, and there needed to be a response to this, and the bar associations and the courts needed to anticipate how they could make the system continue to work when people were going to courts with greater frequency without direct representation. And so unbundling was designed to be a win-win-win. It's designed to be something that made the representation affordable for pro se litigants. It was designed to be an opportunity for lawyers who were losing marketplace because full representation was not a model that was economically feasible for the pro se litigants. And it was designed to be a win for the courts when people appeared before them, instead of having no insights, to having some insights. And frequently enough insights. So when we started to determine whether or not this was an appropriate response, what we heard from lawyers was that we're uncomfortable with the ethics dimension to it, and we're uncomfortable with the malpractice exposure. And so we created Model Rule 1.2c, which Katie discussed in detail. The New York rule is a little more detailed than the ABA model rule, but essentially it's reasonable under the circumstances with informed consent of the client. There was a debate about whether or not it should be in writing, and at that time there were a lot of hotlines, and writing was just not a feasible method of providing limited scope representation, and so that did not make its way into the rule. No question that's a best practice, no question that that's a measure of protection, no question that Katie's example being an exception, can limit your malpractice exposure. California had an interesting experience with their malpractice carrier. They had a captive carrier there, and they asked that they cover unbundling, and the carrier said, well, we don't have a history of it. And they said, we know it's happening, but we don't have a claims history, so we don't know how to price that out, basically. And the bar said, well, wait a minute, you know it's happening, and you know there aren't any claims, so what's the problem? And so they came to an accord, and they figured out how to provide coverage for that. And obviously it's something that people who do unbundling need to make sure that their carriers are aware of. And then, so about 42 states have now adopted 1.2c, and with some variations, like New York's. I should note, in the other states that haven't adopted that, no state has a prohibition against limited scope representation. So it's something that can be done. It's just a question of what the standards are. We'll hear more about facilitating rules, what I call facilitating rules, including ghostwriting. Under what circumstances is it appropriate to ghostwrite? Under what circumstances do we manage the obligations under Rule 11 and the state's comparable provisions of Rule 11? And under what circumstances do we have limited appearances in court and expedited withdrawals, where you can withdraw in a way that's something other than the discretion of the court, and by notice, having fulfilled the obligation, the contractual obligation the lawyer has with the client. So we have, the ABA has drafted a paper that collects all of these state rules, and certainly not all of the states have addressed these rules. It's a fraction of the states, but we've created that to enable the states to see what other states have done, and to encourage them to fully address what the parameters ought to be. So where are we today? We have the 42 states that have that. We have a series of opinions on ghostwriting, and we'll be looking at the New York experience with that this afternoon. And we have research that indicates to us about 37% of lawyers are unbundling. And if we look at the demographics of that, for sole practitioners, who are those most likely to provide personal legal services, it's almost 50%. It's about 47%. So it is something that is pervasive, but consumers are not as aware of it as they ought to be. We did research in 2010. Where we looked at how people found lawyers, and among those questions, we had a little paragraph, and we said unbundling is a form of representation where you partner with your lawyer, you provide some of the services, the lawyer provides the rest of the services. It may take more of your time, and it may be less expensive. How familiar are you with unbundling? And very familiar, somewhat, a little bit, not at all. 70%, and this is a nationwide poll of consumers, 70% said they were not at all familiar with unbundling, which shocked me because we just told them about it. So I figured at least half the people would say, yeah, I know about it. You just read me that paragraph. But 70% said they were not at all familiar with it, and only 11% said they were very or somewhat familiar with it. So it's something that's not on the public's view. But then we asked them, would it be important in your decision about hiring a lawyer that your lawyer offers unbundled services? And 2/3 said it was. And so there is a demand for it. There is an interest in exploring it. Not that it's appropriate for every circumstance, because clearly it's not. So what is unbundling not? Katie talked a little bit about this. It's not limited representation. And anytime you hear somebody say limited representation instead of limited scope representation, you know where they're coming from, okay? They don't like this idea. But it's not limited representation. It's as full a representation. It's only the scope that is limited. The lawyer has that full obligation for competence that they would if they were providing full representation. And this is a point that I think is very important. It's not what you do when you set a retainer and the money runs out and the client can't pay for it any more representation. Okay? That is not limited scope representation. Limited scope representation starts with the limitation at the limitation of the scope at the beginning of the representation, and we see this all the time in every setting where there's a retainer. A moderate income person pays that retainer, expects that that's going to resolve the matter. The matter is not resolved. The lawyer asks for more money, and the person says, I just can't pay it. And so the lawyer is faced with the obligation to try to withdraw, which may or may not happen, or foist obligations onto the client, or proceed pro bono, and none of which have a great conclusion. That is a no-win. So we see that, so people define scope of representation at the beginning of the representation. They agree on that, and it changes. Things change, just like if you were building a house and you say to the contractor, I want a light switch over here and I want a sink over here instead of over here. And those things change, and they add to the expense, and they add to the complexity, and that's built into the way that this model is delivered. But it is done with forethought, it is done with agreement, it is done with conversation. So what do we need to do at this point? Well, the states that have not fully changed the rules, we hope that they will address that and do so. It's an arduous process. It takes a lot of time, energy, and insight to do that. We need to have public education. We need to make sure that people, that consumers of legal services, understand the array of options that are available to them. We need to have education of lawyers to understand, among other things, the ethical dimensions, the issues that Katie brought up today. And we need to have judicial education because I think the judiciary has the capacity to frustrate the efforts to deliver limited scope representation in various places across the country more than anyone else, because if a judge insists that someone come into court and they have a lawyer and they beckon the lawyer in violation of the attorney-client agreement, the lawyers are simply not going to do that. They're not going to provide that service, and I think that's an unfortunate consequence. And the final thing we need to do is to not assume that this is done perfectly. We need to make sure that everyone understands that limited scope representation is appropriate in certain circumstances and not in others, and we need to constantly evaluate what's happening, because it is a process that, if not fully mature, at least is in its adolescent stages. We have a history now. We can determine the circumstances under which it is appropriate to do. We can evaluate the outcomes and make decisions about going forward. So thanks for having me.
So, Will, the American Bar, can you hear me? American Bar Association passed a resolution on limited scope representation not too long ago. Could you just give us a little background on how that happened? Sure.
For a long time, the ABA recognized unbundling and did some research in terms of its success, and wasn't dedicated to it as a process that it was designed to expand access. And in 2013, the Delivery Committee joined with other committees to bring a resolution to the ABA House of Delegates encouraging all the stakeholders, the courts, the bars, the practitioners, to provide limited scope representation and to analyze the outcome of it. So this is part of our mission now. This is something that we support. One of the nice things about having ABA policy is it enables us to participate in amicus briefs. So if the circumstance were one that unbundling were part of a court challenge or decision making, we would be able to come in as a friend of court on that, and also to articulate the benefits that we've discerned so far.
Are there resources available on the website for the Delivery Committee?
Boy, howdy. Yeah, we have an unbundling pro se resource center, and it's not designed for the practitioner as such. There are resources for practitioners. Woody Mostyn wrote a book on unbundling 20 years ago. Stephanie Kimbrough's written one more recently that has some technological insights into it. But our resources are more so focused on policymakers, focused on the courts and the bars and how to implement these rules, how to draft and progress these rules and ethics opinions that will prevent the necessity of reinventing the wheel and having the information accessible to go forward with it.
You know, you mentioned Stephanie Kimbrough, and I've met her. She does a fascinating practice. Could you just share a little bit about what she does?
Yeah, well, Stephanie is a virtual lawyer. Actually, she's right now doing a fellowship at Stanford, but her law practice has been based in providing legal services online without ever meeting her clients and face to face. And she uses technology tools, and really the flip coin of that is Wayne Moore, who's joined us today. And Wayne has a really excellent paper that he submitted to the ABA Future Commission, the Commission on the Future of Legal Services, about his experience as a storefront practitioner providing unbundled legal services. So there's lots of different ways that this is being done in the marketplace, and it's limited only by people's imaginations.
Are there any other interesting models that you would like to share, like coffee grind, or they'll go on there?
Sure, yeah. There's a coffee house called Legal Grinds where they serve Java and Justice for $30. You get a cup of coffee and a 20-minute consultation with a lawyer. And on their chalkboard, they have Thursday night immigration, Friday night domestic relations, Saturday night bankruptcy, and people can go in and learn more about that. There's also a barber shop where the barber's a lawyer, and he'll cut your hair and tell you about what your legal issues are. And there's also a hot dog stand. Actually, the hot dog stand, I think, is closed down, but the guy had a dedicated period of time where he'd take people in the back and talk to them about their legal problems. And those are the consultations, which are really the most common part of unbundling. We see that with prepaid legal services. We see that with hotlines still. We see that with online legal services where it's Q&A, and the consultations are really that's like the front. That's the first of those popsicle sticks that Woody had, and that's one part of it. Obviously, ghostwriting's another, and limited scope in court is the third part of that.
Is it a fair statement to say that people, particularly moderate income people, are looking for things that work the best for them?
Yeah, I think people are. I
think
think people. You know, there was
I'm a
ABA.
judge, so I can do it.
There was an ABA study several years ago that demonstrated that people spend more time shopping for a refrigerator than for a lawyer. But that notwithstanding, I think people are pretty sophisticated legal consumers, and I think and as the study demonstrates about how people find lawyers in the role of unbundling, and that there is an interest in having a discussion, not necessarily going forward, but having a discussion about that. And one of the things, there's an emergence of incubators across the country, legal incubators for law firms, young lawyers participating in these programs that help them establish their practices. And one of the things that we see emerging from that is an understanding of the role of unbundling and how to present that to the consumers as a choice. And we see this on their websites over and over again, that they're doing discrete task representation, as we put it in some cases. And if I were a practitioner, established practitioner, competing with some of these incubator lawyers, people say, well, isn't it awful that the bar supports these people that are going to compete with us? Yeah, it is. I mean, these folks are really bright, and they're willing to experiment and implement these things that aren't being broadly implemented. And I think that's a really interesting feature to what's happening today.
Thank you, Will, for understanding what I was asking. That's Will. And one last question for you. You teach in law schools, and I do as well. Every time I ask my students about unbundling, they look at me with a blank look. Do you think that law schools are doing what they need to do to ensure that law students are aware of this model of practice and the ethics involved and the viability?
Yeah, I actually am teaching a course at Chicago Kent Law School. It's called Practice and Professionalism, and it's part of an emerging philosophy that we need to have lawyers who are more practice ready. and we include in that conversations about unbundling, including the ethical dimensions to it, but as well the practice dimensions, and we do that both in the private sector and in the public sector. And I think that we're seeing this emerge. I did a presentation on unbundling with the National Law Placement Group. I can't remember their exact title, but I started by asking them how many of them were familiar. At fully 80% of the law placement folks in law schools raised their hand and indicated that they were familiar. Now, maybe that's a self-selection because they came to a program on unbundling, and maybe they received those phone calls where we described what it was, but nevertheless, I was surprised to see that level of awareness. And as we see, we take law students and we include them in self-help centers. That's part of unbundling. We have them doing internships that feature document preparation. That's part of unbundling. So we're seeing this kind of a transformation where they're becoming more and more aware of it as a concept.
Well, we've seen some resistance here in New York to using limited scope in the representational side of things. And are you aware of any movement in the country that addresses that issue? And do you have any thoughts on that?
Well, I think the comforting aspect of that is to understand unbundling's not for everybody, it's not for everything, okay? But on the other hand, full representation's not for everybody either. As we, when I have conversations with people who are antagonistic against the concept, they always bring up to me that you can't unbundle medical malpractice. I'm like, yeah, and you don't need full representation for a name change. So there's and the beauty of standard 1.2c is reasonable under the circumstances. I wish I could take credit for having come up with that, but it's a brilliant concept. You have to judge two things to determine reasonableness. You have to judge the complexity of the issue, and you have to judge the capability of the client, because some clients are far more capable than others of doing things that will enable them to accomplish their need for justice, right? So it's two scales, and it's complex, and it's something that mandates that level of competence that Katie was talking about.
And would you agree that some law students are more capable than others, and with proper supervision they might be able to do? Yeah,
I mean, we see law students doing volunteer work and doing pro bono work and doing self-help center counseling, and they're pretty good at following directions, is my experience, and a very helpful resource for these sorts of things. And I think law students are as or more cautious than lawyers, because they haven't got the ticket yet, right? So they have to be really careful. But they're certainly a valuable resource for many of the platforms in which this takes place.
Thank you, Will.
Thank you.
Judge Fein, tell us what's going on in Massachusetts.
Okay, I will. But first, let me thank you, Judge Fisher, for inviting me to be here, and thank you all for permitting me to speak with you for a few moments, and of course thank the New York State Bar as well, and say how pleased I am to share the panel with my distinguished colleagues here. So I think the instruction from Judge Fisher was that I should speak only about LAR, but I'm not going to do that. No, I will.
You know how judges are.
Right, exactly. No, I will, but I really, if you'll permit me, just want to take a moment to set the context for the conversation in a couple of regards. Judge Fisher mentioned that I'm a housing court judge. I've been on the bench for 16 years now. And so my day-to-day experience is several-fold in regards that I think are relevant to this discussion. First of all, over 90% of the tenants that appear in front of me appear, I know the correct term is self-represented, but I like to say unrepresented, because I think there is an important difference, and in my experience, most of the litigants who are not represented by attorneys are unrepresented. And something like 55% of the landlords who appear in front of me are also unrepresented. So that's an aspect of the reality that I deal with. Another dimension is that we have a number of programs in our court, including in-house mediation programs, and including a lawyer for the day program, and including a program that deals with tenants whose mental illness is sort of jeopardizing the tenancy, or at least the manifestations of that condition. And so the point of that is that there are many ways to take an off-ramp before people appear in front of me in the courtroom. And almost by definition, that means that the folks who do appear in front of me either have a complicated legal situation or personal, perhaps cognitive limitations that make them probably the least able to effectively represent themselves in the courtroom. So those dynamics converge to make me an enormous fan of limited assistance representation, and I should say that right out of the gate also. In Massachusetts, we call this phenomenon limited assistance representation, not limited scope representation, but it's the same thing. Two other preliminary comments, and then I'll get into it. I want to give a big shout out to my colleague on the appeals court in New York, a woman named Cindy Cohen, who really launched this effort in Massachusetts probably, I mean, you all know better than I, but it's probably 10 years ago at this point.
Least, yeah.
So some of what I'm going to describe in terms of the background is really her good work, and I inherited that. So thanks to Cindy. And then the other thing I'd like to say is that the Conference of Chief Justices this past summer, that is the Chief Justices of all the state court systems in the country, passed resolution number 5. Is that well known to this group? Or so as I understand it, and I wasn't there, but as I understand it, resolution number 5 basically says, and Will and Jim will correct me if I've got it wrong, that the Conference of Chief Justices is committed to 100% access along a continuum of appropriate services. Very easy to say, very difficult to make happen, but my point in raising that is that limited assistance representation, limited scope representation exists along, hopefully, a continuum of services that are intended to meet that goal, to deliver 100% access. And so I will echo what others have said, which is it's not for every situation, it's not for every client, it's not for every lawyer, but it's a hugely important tool if we are ever to even approach achieving that goal that's been established by the Conference of Chief Justices. So that's sort of some context. I should also say that limited LAR, we call it LAR, is, as far as I'm concerned, a win-win-win. Lawyers, clients, the courts, win-win-win. We have all of these data about the fact that people are graduating from law schools by the thousands and not able to find clients. Clients are coming to our courts by the thousands, not able to find lawyers. The courts are, we're all pulling our hair out in the courts, the state court systems in particular, because of that. And here is a way to connect that unmet need from both perspectives, presumably much to the betterment of the system in its entirety. So I guess I've now made the point that I'm a fan. I'm very proud of what we've done in Massachusetts, but there are some lessons learned along the way, many objectives not yet achieved, maybe an unintended consequence or two. So I'd like to take, the opportunity to speak about all of that. And what I thought I'd do is tell you what we went through to institutionalize LAR in Massachusetts, how it works, and then some of those sort of higher level lessons. Does that sound all right?
That sounds fine.
And again, friendly amendment to Judge Fisher's instruction. Please do feel free to interrupt with questions along the way as far as I'm concerned. So we started LAR in Massachusetts as a pilot in one of our 7 court departments, and that's perhaps something I should explain. In my experience, all state court systems are funky in their own way. And our particular oddity is that we have a court system, a trial court that's comprised of 7 different trial court departments, I sit in the housing court. We have a probate and family court, a district court, superior court, land court, juvenile court, and a court system that's just for Boston. It's called the Boston Municipal Court. And each of those has a chief justice and an administrative office, and each reports up to the chief justice of the trial court, who in turn reports up to the chief justice of the Supreme Judicial Court, a person named Ralph Gantz, who may be known to some of you in the room. So when we were wanting to think about how to launch LAR, we had to do so within that somewhat Byzantine structure. And those of you who practice in New York may find that you have your own Byzantine structures that you need to accommodate, and some of my comments may not obtain. But so we piloted in the probate and family court. We chose 2 divisions of the probate and family court. We got all the and Laura will explain more about this. We got all of the stakeholders together or represented, the judges, the court personnel, the practitioners, both private and legal services, the insurer, the malpractice provider, the organized bar, and we piloted it. And obviously we had seeded the ground sufficiently that it was very successful, very well received, and we did a little evaluation in the form of surveys, the results of which were very favorable. And that then laid the groundwork for the Supreme Judicial Court to do 2 things in succession, the first of which was to roll it out across the probate and family court beyond these 2 pilot sites, and the second of which, and here's sort of the first thing that I'll comment about as perhaps not having been, in my opinion, exactly the right way to go, but what the Supreme Judicial Court did in Massachusetts was to issue an order authorizing each of the trial courts that elected to implement limited assistance representation. So we have a bit of a hodgepodge in that in Massachusetts, 5 of our 7 trial court departments have adopted LAR. The juvenile court and the superior court, which is where the felony cases and the big civil cases take place, have not adopted LAR. So we don't have uniformity across the court system, and I think that's unfortunate and not necessary. And secondly, because it was left to each department to adopt or not LAR, they did not do so simultaneously, and so we have a little bit of a clunky set of not precisely identical departmental orders, departmental forms, etc., departmental practices. I intend to try to standardize all of that as one of my next undertakings working on the access to justice side in the trial court, because I think it's a little confusing to the bar. It's not what they want. It's not necessary. They're silly little differences that don't seem necessary to me. So I would commend to those of you who are thinking about LAR to think right out of the gate about the possibility of coming up with a uniform approach, whether that means, and I don't pretend to understand the complexities of your system, but there are a number of reasons to do that, including that you want, looking back, to be comparing apples and apples. You want your data and your evaluations to be meaningful, et cetera.
I should stop you and tell you that we are the New York State Unified Court System, but we are not the New York State Uniform Court System.
Yeah, okay, so I get it. But you know, I want you to understand that that happened in Massachusetts, and it may bear on some of my comments. As I said, 5 of the 7 trial court departments have adopted it. By far, it is used most often in the probate and family court. It is also used in the housing court where I sit, not as much as I would like to, and in particular not as much on the landlord and paying client side as I'd like to see happen. I'll talk about that perhaps in a moment as well. And it really has just not, and oddly it's used a little bit in our land court where we do property disputes and that sort of thing, because the judges there really promote it. It's not that there's a huge need, but as to the relatively limited need in that department, the judges very much promote it. So that's sort of the landscape. here's how it works. As I indicated, each of the trial court departments has its own standing order, but they have some common principles. And they authorize limited assistance representation. And importantly, in light of some of the comments that I've heard so far today, they make it, these standing orders make it essentially sacrosanct for the courts to honor the limitation of the scope that the attorney and the client agree to. So when I see a lawyer appear and withdraw in the same hearing, as is typically what I see, and I'll explain that in a moment, and I want to go, please stay, I can't. I can't say that. I can't, even raise an eyebrow, or maybe I could raise an eyebrow, but I don't, because that's the deal that we have made with the bar, that if people file a limited appearance and they withdraw pursuant to the scope of that representation, we will honor that limitation, and we will not guilt them or get in the way or anything like that. Incidentally, the materials about our limited assistance representation program are available on our trial court website. So if you Google Massachusetts Courts Limited Assistance Representation, you'll get a landing page for all of the stuff that we have on LAR. Look at it again in a couple of months because we're working on improving it. It's a little balkanized as a result of the structure of our court system, and I don't like that, so we're trying to make it better. But it's all there, and I think there's some materials on there that would be of interest to you, and I'll get to that in just a moment. Anyway, limited appearance, we have to honor it. We have standard forms. Ghostwriting is permitted in Massachusetts. We do not require the attorney who is doing the ghostwriting to identify himself or herself. We do require that the document have a designation that it was prepared with the assistance of counsel. So I know that someone helped, not that I really need that label, I have to tell you, I can tell. But I don't know who did it, and I can't call that person in and say, why, so ghostwriting's okay. We honor the limitation. What we require is for lawyers to go through a very easily satisfied, I believe Laura will confirm, training process. And we offer the training in a number of different forms. There is a training manual on the page that I just described, and parenthetically, I'd like to give a shout out to the students in a class that I was teaching at our local law school a few years ago, a class on access to justice. Those students had to do a project for their grade, and a group of them took a pass at the first draft of this training manual, and then we took it as a court system and modified it, and now it's up on our website. At the end of that training manual are some standard retainer agreements. I heard some discussion earlier about what those might look like. Obviously, they are reflective of Massachusetts principles, so please view them accordingly. But I just went and looked at them earlier this morning again, and they're very interesting, they're very extensive. I think Laura will tell you that the key is to be really, really specific up front with your prospective client about, and get confirmation in the form of check here, check here, check here about what the limitations of that representation are. In any event, we require lawyers to do this training either by using the training manual that we provide or by attending a continuing legal education program on LAR, or there are a series of video presentations available through our website. And then the lawyer self-certifies that he or she has done that training program. We do not have a uniform policy in the court system about maintaining lists of LAR lawyers. We will soon, because I'm going to make sure that we do. Some of our departments do maintain those lists. Others have been concerned historically that that somehow lends the imprimatur of the courts to anyone on that list. I don't think that's right. And so we're really, I think, on the cusp of saying, once you've certified, we'll keep a list of you all on our website with information like what practice area you're prepared to do LAR in, maybe what your fee structure is, whether you speak any non-English languages, other sorts of information to make it easy for clients to find you. And one of the reasons, in addition to the fact that why wouldn't you do that, one of the reasons that I'm promoting that idea now, and I can say it's being favorably received, is that the bar has asked us to do that. They're basically saying, this is a way for us to get more business, help us get more business. Yes, sir.
Well, I wanted to build on that because my name is Wayne Moore and I practiced on Bible law for 3 years in D.C., Virginia, and Maryland. And I've written extensively about it, and I'm of the firm belief that the courts have it within their power to make unbundled legal services widely available to moderate income people, and most courts refuse to do this. And the way you do it is exactly what Judge Fein said, is that you actually put up a list, a referral list of unbundled. I've searched the court systems, and I find 2 courts that have done it. Yours is the third, and I applaud it. One is Alaska, and one is Maricopa County.
Right.
And in both places, lawyers routinely make a living doing unbundled practice. However, I can tell you that lawyers in D.C., myself, and Virginia, and Texas, and so on, are all struggling, and the courts are refusing to provide such a list. And what they say, some of them say, well, we're going to refer them to the moderate income bar referral, but most of those bar referral people will tell you they don't get enough volume to support a practice for even one person, a few. How do we get your belief accepted by all the courts and also the Judge Fisher is, and we count on New York to do this?
Sorry, kiddo.
Well, we're at the beginning of our journey here, but I just want to sort of paraphrase what you said to make sure that the people in Albany may have heard you. And I'm going to ask anybody else that has a question to stand up and speak very loudly so we are sure that our friends in Albany can hear you. The gentleman who's speaking, his name is Wayne Moore, who is an unbundled limited scope practitioner from the Washington, D.C. area. His feeling is that the courts do not encourage the unbundled practice, that only Alaska and Maricopa County in Arizona actually have lists of limited scope attorneys that are available to the public. Massachusetts apparently is going to work on it, and he believes that the courts can do more to facilitate unbundled practice that would be in the interest of particularly moderate income individuals.
If the courts do it, the attorneys will come.
Yes.
And his opinion is that if the courts will do it, the attorneys will come and people will use them. I paraphrased you, I'm sorry.
So
Judge Fein was asked. and
Yeah,
she's
no,
gonna
I'd love to
respond.
respond to that because it, first of all, at the most conceptual level, I will share my optimistic view that the leadership of the state court systems around the country are just about at a tipping point on a number of aspects of providing enhanced access to justice, and this is one of them. When someone like Ralph Gantz, who's the Chief Justice of the Supreme Court in Massachusetts, is who he is, and is as committed to these principles as he is, and is making that known nationally, I think what we're seeing is a wave building that I feel, and this is in my nature, but why not, very optimistic about. I think we've got to get there. And when we have a resolution from the Conference of Chief Justices saying we need 100% access along a continuum of appropriate services, that tells me a few things. A, we need 100% access. B, the people who are promoting that goal understand that we are talking about a continuum of services here, and the challenge that lies ahead is to triage unrepresented litigants appropriately into that continuum, and you've got to have the resources on the other side of that triage, or it's for naught.
No, we have presented these judges with that exact resolution.
Yeah.
Showing that they should be able to do it, and they're refusing.
Yeah, well,
Chief Justice.
I know because Judge Fisher and I were both a part of a program on limited scope representation in D.C. earlier this year. She made it, I got waylaid. But, and I know that you're right on the cusp of really, your jurisdiction is right on the cusp of trying to educate its judges about this. The other point I would make is, I think it's true that all state court systems, the filings are going down. I don't know if it's true that all state court systems, but there is this phenomenon across the country, perhaps Will knows more, about filings going down in state court systems. People who can are opting out of the public justice system and into the private system to one extent or another. One of the consequences of that, from my perspective, is that court leadership is very interested in keeping you all, lawyers, engaged with our systems. And in my experience, hearing from the bar what the bar needs in terms of limited assistance and limited scope representation is very compelling and is very influential on court leadership. All of this is a not so subtle way of saying that if you lawyers need the courts to do something in terms of limited scope representation, you should tell us. You should tell us through. I just solicited just this kind of input from the Boston Bar Association, which is a hugely influential organization in Massachusetts, and they wrote me a 2-page letter saying, please do A, B, and C. It will not shock you to hear that I was hoping that they would say, please do A, B, and C. And so that's been forwarded on to our leadership, and I think that that will get traction.
Thank you, Judge Fein.
Yeah.
I'm going to move on to
Yes,
Laura.
absolutely.
We're running out of time, but in this case in New York, the court is saying, I want to hear from practitioners who are interested in developing and having the courts accept limited scope appearances in court settings. And we have a number of judges here, and I hope you guys have your ears open. And we have a judges panel in the afternoon that will discuss some of the issues that the judges have come across with respect to limited scope representation and why they think it's a good idea. Laura, you got your boots on the ground. You are a limited Massachusetts limited assistance representation lawyer. I'm particularly excited because you do family, and we have very limited models in family law. Tell us what you do, and do you make a living?
I make a living. I make
Okay.
a great living, and I will
Pay the
say,
bills.
and I pay the bills, and can be a foodie myself. So that says half of it right there. I did get certified during the initial pilot program. I practice in one of the 2 pilot program counties, and that is Suffolk. And I'm not sure of the exact number, but I would say high 70%, perhaps even low 80% at times are pro se in the probate and family court where I practice in Suffolk County, I will say, and that's Boston. I was delighted at the time and even happier when it rolled out to all the other counties. I'm not going to address the pro bono perspective or so much the access to justice perspective, though I am a strong believer in it, and my client base ranges a great deal. I do pro bono work. Many of my clients are modest income people. They come in, perhaps a lot of my practice is divorce, custody, property division. I do a lot of issues relating to children and property division. There are a lot of modifications. That goes up and down in my field, certainly. I started using LAR, limited assistance representation, when I went out on my own about 8 or 9 years ago, even more than I had when I was with my prior firm, a very small office at the time. More and more people came to me and they weren't sure if they could really commit to the retainer that I needed, because in Massachusetts, and I suspect from what I heard in New York, very similar, once I file my notice of appearance, I'm in the case unless I'm allowed to withdraw, or the rules provide for certain circumstances under which I can actually provide a notice of withdrawal, as opposed to making a motion. but it is difficult. Even if a client says, I don't want you anymore, I can't afford you, you still have an obligation. So with limited assistance representation, before LAR, many attorneys required a large retainer that people just can't afford to do initially. Maybe they don't understand why you would need such a big retainer. It's a simple divorce. Everybody's divorce is very simple, uncontested. And as you saw from the hypothetical earlier, things can change quite suddenly. And it's hard to know during an initial consultation exactly what the scope of the representation will be. I will say a couple of things probably numerous times during my conversation with you, and it is the responsibilities of a LAR attorney or a limited scope practitioner is the same as any other representation you will ever have. We're attorneys, we have ethical obligations. So the responsibilities are the same as in regular practice. I do agree that there may be a little bit more communicating involved with it. So I've actually had an outline, and I've added things as the morning program's gone on, so I'll try not to be as jumbled as I've been. I agree that with Katie that the competence might be a little bit more. You need a little bit more competence, perhaps, with LAR, because you need to understand what the representation can be in order to explain what it is and isn't with a potential client. In Massachusetts, we're required to provide a written fee agreement or a written engagement letter. That changed fairly recently. Before that, it was just a best practices. But for LAR purposes, I think it's more important than ever to provide a written agreement. And the materials that you'll find on the Massachusetts Probate and Family Court's website will include some of these retainer agreements. I happen to bring some with me from a program I did a long time ago for Judge Fein. And that includes the engagement letter, which lists a variety of issues and events. And in Massachusetts, we break up LAR, we can break up LAR by issues or events. What do I mean by that? An event may be I will appear in a limited assistance representation capacity in a motion for temporary orders. And I know I'm repeating several things that Judge Fein said, so please excuse that. But I will provide the court on that day with my notice of appearance, my notice of limited assistance representation appearance, and at the very same time, forgive the judges for hearing this, I know technically I shouldn't do it. I can't file a notice of appearance and withdraw immediately, but for clerical reasons, often the clerks will allow me to provide it in the file immediately, because after that hearing, I'm out. It's not a motion to withdraw, it's a notice to withdraw. And I've never had a judge, I'm sure they were shaking in their boots saying, I wish you would stay on, Laura, but they've all accepted it freely and voluntarily, and they appreciate the fact that I'm there at that time. I will add the other thing that judges will allow. In Massachusetts, we have a next court date system, so theoretically, you're not supposed to leave until you get the next court date. Even though I'm not representing the client after that hearing, I have always had judges accommodate me at my request to consider my calendar as well when we're doing the next court date. So that's worked out very well. So what are some of the reasons I use LAR, or how do I use it in my practice? I've thought about several of my past LAR clients, and my entire practice is not LAR, but it does come up on a number of vehicles to me. The court does have a list. It's a little outdated at times, but the court does have a list of LAR practitioners, so I get referrals that way. The Boston Bar Association has a lawyer referral service, and one of the items you can check off, in addition to them knowing I do family law, is that I practice LAR. So sometimes clients will actually call and ask for an LAR attorney, and they are able to be put in touch with me as a result. The Mass Bar has a referral service also. I am not sure if they provide that option for people. So I've had clients come to me and they are not sure just yet if they want to hire an attorney, if they need an attorney. I've had clients come and they are absolutely certain that they need an attorney, they can't do this alone, but they really don't have all the money for it. I should back up and say that there is some confusion at times that LAR means low bono, as some people call it, or reduced fee, or free services, or flat fee services. It may include any of those, and I do charge sometimes reduced fee under certain circumstances. I never charge a flat fee, though some of my colleagues do, for LAR services and other areas. But most of my LAR work has been at my regular hourly rate, no reduction. The difference is that by committing to the client and the client committing to me for just a portion of the representation, I can request a smaller retainer fee and get a better idea, perhaps, as the case is moving along, how much the case will cost. What are the circumstances that will increase the cost? Is it truly an uncontested divorce? And as those of you who practice in this area know, uncontested doesn't mean that there aren't still issues that need to be addressed. There's still property division issues, parenting plan issues, or I heard visitation here. Massachusetts has moved in the way we describe it as a parenting plan. That in itself takes a very long time to do if you do it right and well, particularly with parents who are co-parenting. Sometimes I will just go ghost write, as it's called, and always with the signature of the pro se litigant prepared with the assistance of counsel. I have also used it to negotiate. After a matter's been filed in court without my signature, but as prepared with the assistance of counsel, I've talked to opposing counsel. And this gets back into the idea I mentioned earlier about communication. Some practitioners, I believe, actually share their fee agreement with opposing counsel so they understand the scope. I've never done that. I actually don't think it's an appropriate thing to do, but in any event, communicating with the other attorney or the other pro se litigant, opposing party, these are the things that I will take care of. These are the issues that I will take care of. And to be as clear with them as you have with your own client makes for a very effective representation all around. I think earlier it was talked about, is no representation better than bad representation? I think everybody probably chuckled at that, of course. From the court's perspective, it is often the case that LAR is better than no representation at all, and that assumes that there's good representation to be had. From a practitioner perspective, LAR could be better than full representation because the money does run out, and I, more often than not, get paid for all of the work that I do. I was talking about the communication, and when I talk with my own client, I will go through the list of issues or events that I will be responsible for. As it relates to responsibility, ethical responsibilities, if it doesn't seem like an area that can be unbundled or separated between me and the client, I don't do it. It's really that simple. For instance, a financial statement. In Massachusetts, the lawyer signs the financial statement, and I'm saying that I've reviewed the financial statement, I've prepared it, I believe this to be, with due diligence, fair and accurate description of my client's financial status. and financial situation. I can't divide that up to just have a client give me a financial statement that I have to sign without actually reviewing the financial documents necessary to do that. So it's really just practical common sense that I use most of the time in this practice. If it doesn't work and I'm to go into court to argue in temporary orders or any other circumstance financial issues, I have to be comfortable with the financial statement. It's just simply not something that in my mind can be unbundled, and if that's not acceptable to the client, then there's not informed consent. It's not a reasonable time to do LAR representation, LAR practice in that engagement. What happens when the scope changes? Very simply, as in every other area of practice, I just do a new engagement letter. And the items, the issues, the events change, and they're just simply updated. And I can start my representation or continue my representation. And it works out quite well. I would submit that LAR clients, or clients of LAR practitioners, sometimes perhaps have more communication and more involvement in their case than in other situations where the attorney is just handling everything, because that's what we do. We handle things. We've been hired to take care of it. What is, I find, most beneficial for clients, and one of the reasons I think that clients like to hire somebody under the LAR model, is I can probably settle a case far faster and better than they can being pro se. They understand what the law is. I understand what the law is. I understand how the judges will view a particular set of circumstances. I can explain that to the client, and I can explain it and have a conversation with opposing counsel or the other party if the other party's pro se. I know most of the time, and I'm sure many of you would agree, most of the time we know what the outcome of a case will be if we have enough of the facts available to us. And so limited assistance works out for the court, for the practitioner, I know, win-win-win all around, because it often doesn't have to go all the way to a trial of people not knowing what they're doing. I can resolve it perhaps even before ever getting to court. Sometimes during the temporary orders, and I won't go into how our practice is, I'll assume that you understand generally what that is. And then at the pretrial conference, much of my limited assistance representation will be through up till and including the pretrial conference. And the pretrial conference in Massachusetts in the probate and family court context is where many, many cases settle. We're required to have an in-person meeting, and before that, and then write a memo to the judge on the other side of what we believe to be the issues for trial and what we've already agreed to. Very effective way of settling a case. And when there are lawyers involved, cases settle. That's my view, and it seems to be the view of many of the attorneys that I've dealt with on the other side and judges who've also commented. I've already commented that my clients are often paying me my regular hourly rate. They are sometimes of modest means, often of modest means, but interestingly enough, not always. But some people just simply do not want to give a big retainer up front when they can use the money themselves. And if it's not, and the case may go on for several months, we have a time system in Massachusetts, but divorce cases still go on for many months. And so they just prefer to use their own money rather than tie it up in my IOLTA account, my attorney trust account, which is not giving them any interest. Back to communication, again, as I said I would. My notice of appearance is a court-issued notice of appearance. We're not required to use that, but as a best practices, I like to use it. It sort of signals to the judge and to the clerk, she's here on a limited assistance representation basis, and I do the same with my notice of withdrawal. I have, for non-LAR clients, my own retainer agreement, but I've used the one that, I don't know if it was the court actually that issued it, I think it was your committee that issued the engagement letter, a recommended engagement letter. And I've combined both, but what I do use is that checklist of the issues to be apportioned, client, attorney, or other issues and events. And I find that's very effective, very helpful. It takes a little extra time. It's non-billable time. I don't bill for my engagement letters, and I don't bill for the time I'm discussing my engagement letter. But I think in the long run, it is far better to have that sense of communication and the confidence that your client understands what this practice is and what they are responsible for. I also use LAR, one of the issues or events, typically I view events as court dates, but issues may be discovery. And discovery is a very helpful LAR type of thing to use, as opposed to a pro se just getting subpoenas from random websites from a Google search and sending them out, maybe not sending them out correctly. It can be very expensive to get bank statements from 10 years or whatever people request. That's just simply unreasonable. So I know what's most effective, or I'd like to believe I know strategy-wise what will be most effective for somebody to request in discovery. Again, making the whole process a little bit more efficient all around, instead of asking for documents that really aren't necessary, and that may eventually waste a judge's time if you have to go before a judge on a motion to compel items that weren't necessary. So discovery works very well for LAR practice as well. I have had one client where I've been re-upped on the LAR basis numerous times and did eventually trying the case. It was not something, it was a very, very difficult case, emotional. It was a custody issue with a lot of extra complications to it, and he felt better about doing it in these various stages. I think all along he knew if the case went to trial that he would retain me for the trial, but he himself just felt he had more control over doing it in the unbundled fashion, also from a money perspective, that he wasn't behind in the bill. He paid up during each segment of the bill. So those are my areas generally. Have I addressed everything? I've tried to take out those areas that others have already commented on. The one piece, I know I said, or I think I said that I don't really understand why there's a lot of concern about these ethical considerations. I don't think there's any more ethical consideration than your regular practice would have you be responsible for. But in looking at some of my colleagues' concerns, I wanted to address from a practical perspective what some ethical concerns are. One has been, when you draft a motion, what happens when the client actually argues it? And the motion has been drafted, and it states that it's been drafted with the assistance of counsel, so the judge will know that and will likely know that there's only so much you can provide for a client. But part of the LAR may be just consulting. maybe ghostwriting and consulting and preparing somebody. But the judge will know that, and I don't think that you have any additional ethical consideration other than making sure the person knows what you've drafted and the best argument that you can make. If you are concerned with that the client will not be able to represent what you've written appropriately and you're uncomfortable with it, I would simply say you perhaps shouldn't draft it to begin with if you're uncomfortable with it. I do know that some practitioners have actually filed the motion themselves to make sure that there's no change in the wording, particularly if it says prepared with the assistance of counsel, and I think that's an interesting option for people to do. In this age of technology, it's really quite interesting and easy, I should say, to email a Word document and have somebody change it quickly on the computer and really change what you intended it to be. There was also a concern raised by colleagues and this morning that you only have limited time to learn about the case. Are we doing things too quickly that, in fact, we're not being fair to the client? Again, I would say you have the same responsibility as we do to our regular clients with whom we engage for the whole case. It is important for anybody that is involved in LAR, both the client and the practitioner, to understand that part of the cost will be learning about a case. And it may be, if you're just doing an isolated part of the case in the middle of the case, it may simply not be economical for somebody to hire a limited assistance representation, because you are still required to know about the case in order to give them the appropriate guidance that they need or to represent them appropriately. And if they're resistant to allowing for that additional expense, then I would submit it is not a good case for an LAR matter.
Thank you, Laura. And I just have one question, and then we're going to move on to Jim. And
sorry, I didn't look at the clock.
No, it's fine. I think it's important to hear from somebody who's actually doing the work. In Massachusetts, since you have a training and the LARs are certified, do people advertise themselves as being certified LAR lawyers? Judge Fein, go ahead.
I know people who do
Yes,
the sort of the entrepreneurial lawyers, the ones who have websites, you know, the kind of thing that people my age never even dreamed of. I know that folks will promote their ability to offer LAR as on their websites. And there's a woman who's now running our court service center in Western Massachusetts who had an entire practice around doing limited assistance representation.
All right. Jim, you're last up to bat. I'm going to throw you a loaded question. Should low-income individuals have access to the full continuum of legal assistance, including limited scope representation?
Yes. I'm grateful to Judge Fisher for inviting me to join you today. Judge Fisher is a personal hero of mine. She is a national leader in improving access to justice. She's not only a visionary and an innovator, she's a pragmatist and a doer. And she has a singular focus on addressing the needs of the users of the court system. I wish I could clone her. I'd like to offer a national perspective on the issue of using limited scope representation to address the legal needs of low-income people, particularly those who qualify for legal assistance at a Legal Services Corporation-funded legal aid program. My perspective on these issues comes from my work as president of the Legal Services Corporation, which is the country's single largest funder of civil legal aid for low-income people. We are funded by an appropriation from Congress. We make grants to 134 independent legal aid programs serving every county and in every state and the territories as well. Our grantee here in New York City is Legal Services New York City, whose executive director, Ron Rasmussen, is in the fifth row. Our grantee in Albany is the Legal Aid Society of Northeastern New York. Albany is my hometown.
And Lillian is in the room in Albany.
and Lillian Moy is the executive director there. Funding for legal services, the resources available for low-income people, is by any measure woefully inadequate. The population in the United States financially eligible for assistance at a legal aid program today stands at 63 million people, fully 20% of the American population. At the same time, though, funding for the Legal Services Corporation on the basis of per eligible person stands in inflation-adjusted dollars at an all-time low. Our current appropriation for grant-making to legal aid programs amounts to less than what Americans spend every year on Halloween costumes for their pets. No. Use that as a point of reference. The situation has been exacerbated in many states by the precipitous decline in IOLTA or IOLA funding as interest rates have fallen to and remained at near zero for coming up on 8 years. Study after study shows that legal aid programs have to turn away 50% or more of the people who come to them for assistance with nothing. 50% or more get turned away with nothing. A recent study by the Boston Bar Association showed that in Massachusetts, 2/3 of people who approach legal aid organizations in the state get turned away with nothing. So for many people, the choice, the comparison, is not between limited scope representation and full representation. The choice is between limited scope representation and no help at all. Now, there are circumstances where incompetent representation may be worse than no help at all. And I advocate limited scope representation only on the assumption that it is provided competently and ethically. I think it's an important, actually a critical tool to try to enhance the resources that are available to low-income people who might otherwise be completely on their own. You've heard the statistics cited over and over again about the number of unrepresented litigants overwhelming our courts. That's true everywhere in the United States, particularly in family courts and housing courts. It is common for more than 90% of tenants in eviction proceedings to have no lawyer, even though in many jurisdictions, unlike Massachusetts, more than 90% of landlords do have lawyers. I'm particularly aware of this in Washington, D.C., where I live and practice. Washington, D.C. has more lawyers per capita than any city on the face of the earth. God bless them, every one. There is one lawyer in the District of Columbia for every 25 residents of the city. There is one lawyer in the city for every 5.4 people living at or below 125% of the federal poverty guideline, which is the standard that governs eligibility for legal aid. Nevertheless, if you go into landlord-tenant court in the District of Columbia 5 days a week, you will see more than 90% of the tenants unrepresented. I don't think that's acceptable. I think we need to do something to reduce those numbers and to make some form of assistance available to more people. Judge Fein referred to a recent resolution of the Conference of Chief Justices advocating 100% access. Their resolution was a follow-on to a summit that the Legal Services Corporation convened a few years ago that Judge Fein and Will and Judge Fisher all attended. It was focused on technology and had as a goal to explore the use of technology to move the United States toward providing some form of effective assistance to 100% of people with an essential civil legal need. Some form of effective assistance. The mission statement recognized that in not all cases is full representation going to be necessary or even available. But if you think about the goal as being turning no one away with nothing, trying to provide something effective for everybody, it really causes you to rethink the service delivery model that we've been using for many, many years, which has had as a goal trying to provide a lawyer and full representation to everyone, even though our experience has shown year in and year out, decade in and decade out, that we fall well short of that goal. My view is this: we can't let the perfect be the enemy of the good. Something competent and ethical, I believe, is better than nothing. So if you think about how we might approach a service delivery model where the goal is to provide some form of effective assistance, you have a spectrum, as Judge Fein mentioned, of services. Sometimes it's going to be online services. There are some states that have terrific websites that for particular legal matters provide good self-help resources. Sometimes it's assisted self-help. It may be something like the Court Navigator system that Judge Fisher has spearheaded here. It may be a staffed kiosk in a courthouse lobby where you have a combination of online resources and a person to talk to. It may be live chat. It may be limited scope representation, and in appropriate cases, it is going to be full representation. To make a system like that work properly, though, you really need an effective triage system to have good judgments made about what the appropriate level of service is under the circumstances. It's a fact-specific inquiry. It depends on the nature of the case, what's at stake, the participation of the client, the sophistication of the client, whether the opponent is represented or not, what resources are available. But if you look at all of those factors and then decide, in this circumstances, this is effective assistance, you may well come up with, you are likely to come up with, something less than full representation in a large number of matters. So I think that the topic today is really critically important to expanding the terribly inadequate resources that are available today to low-income people. We cannot continue to accept a status quo where so many people are turned away with nothing. And I just have two caveats to my otherwise unqualified endorsement of limited scope representation to serve the legal needs of low-income people. Number one, it's got to be provided competently and ethically. And number two, you need to have a system that rationally decides in the particular circumstances what the appropriate level of service is, and not leave it to the client, the consumer, to figure that out on his or her own. Thank you.
Thank you, Jim. I have one last question. What should I say to people who I encounter in New York who say that any movement towards limited scope representation takes away from the Civil Gideon movement? Should I just walk away, or what should I say?
What do we do in the meantime until we have Civil Gideon? What do we say to the clients? Who is suffering the consequence of holding out for that day? I just don't think it's sufficient to tell people who are turned away with nothing at all, we're waiting for Civil Gideon. I'm an optimist. You got to be in the legal aid business. And I do think that there's hope longer term for more resources. But I don't think we can hold off on intermediate levels of assistance hoping for the day that Civil Gideon will come. It's not fair to the clients.
May I add to that? I mean, I could make the argument, I think that LAR could enable Civil Gideon. You know, that if Civil Gideon is shorthand for the right to an attorney when there's a basic human need at stake, then maybe the person doesn't need a full representation attorney. Maybe they just need a lawyer at the mediation in the eviction case in my court in that moment. And so maybe we can move the dial on Civil Gideon by arguing for targeted, limited representation. And I just want to, I really just want to reinforce what Jim has said about the need to triage into the appropriate level of treatment. We're rolling court service centers out in Massachusetts, and that is exactly the framework we're trying to use, is that can be a place, if not the place, where this mass of unrepresented litigants can turn to an appropriate triage, assuming there are resources on the other side of the referral to meet the level of need that some informed professional assesses is appropriate.
Thank you.